All right, big ruling involving the Washington Redskins and their now controversial name. We're joined by our legal analyst, Chaz Farcher from Martin Harding Mazzotti. Hey, Chaz, how are you?
Good morning, Chuck. Good morning, Kelly.
So the U.S. Patent Office, the Patent and Trademark Office, ruled that the Redskins name is disparaging of Native Americans and should be stripped of trademark protection. Now, so what exactly does that mean? I know that doesn't mean they have to change the name.
No, that's exactly right. It doesn't mean anything with regards to name change. What it means is that there may, in the future, not be any trademark protection for the Washington Redskins logos or the couple other things they've trademarked that, look identical to their logos, the way their names are written. So they may not get federal trademark protection, but the reality is they would still have state protection and common law protection. And the reality is this case has already been visited once by the Trademark and Patent Board. It started in 1992. The same decision was rendered 7 years later in 1999, and it was hung up on appeal for almost 10 years. So that's probably where it's headed now again.
So if I'm not mistaken, the last time this, I guess in 1999, I thought they might have prevailed on a technicality. But you're saying you think that the Redskins, the team, will prevail in this case also?
Well, what happened in 1999 was the decision was at the board level was that the logo was still, the trademark board, disparaging to Native Americans. That decision went up on appeal to the district court, and the district court essentially decided no, there wasn't enough evidence to support that, and two, the case was barred by a defense known as laches, which means the plaintiffs had waited too long to bring the case. So that went up to the circuit court and was affirmed on the basis of laches, but not whether or not there was enough evidence. So now we're went all the way back to square one with new plaintiffs, so we can get rid of the undue delay argument. And again, the trademark board has decided that there is enough evidence and laches doesn't apply. So my guess is the next step will be an appeal to the district court on the same issues, and we'll see what happens there.
So in the meantime, can other people start marketing products using their logo and their likeness?
No. The trademarks are protected pending appeal, so nothing can be done at this point. If they lose the appeal at the district court level, my guess is it will be appealed to the circuit court level. If they lose at the circuit court level, they could go as far as to seek review by the Supreme Court. So we could be in the appellate process for quite a while, and during that time, the trademarks are still protected.
Yeah, so you still can't put out your own knockoff jerseys during all this time. And you're saying though that even if they lose after all the appeals are exhausted, the Redskins, that they still may be able to, this would only involve federal court, that they could still appeal it to state courts?
Yeah, all the trademark does is give the Redskins a presumption, that somebody's trying to knock off their stuff. If they have to bring a lawsuit to get some of them, who's trying to, if somebody wants to start the Washington Pigskins with the same logo and selling the same material, or if they want to start the Washington Redskins selling the same logo, selling the same material, but not part of the actual organization, they give the Redskins a presumption that it's their trademark and they would win in a lawsuit. I think what's ironic is that if the appeal is actually affirmed and they do lose somewhere down the road, the only effect of this may actually be to encourage knockoff artists to put more Washington Redskins logo stuff back out on the market.
We're speaking with WGY legal analyst Chaz Farcher of Martin Harding and Mazzotti. Now, Chaz, I know on a local level, there's a case now in Ballston Spa where two kids were playing, and one kid found his father's gun, and one of the children was killed. Now, the family filed a wrongful death lawsuit against the kids where they were playing against the family. What grounds do they have to prove? And the kid pulled it out of a dresser drawer, so what do they need to show in order to get wrongful death here?
Yeah, this is just a terrible case, and it reinforces why you got to keep these things locked up and practice responsible gun ownership. But there are two potential cases when you have terrible circumstances like this. There's a wrongful death action, which is an action that actually belongs to the distributees or those people who would expect financial support from someone who's killed. Normally you see these types of actions where you have a father or a mother of two or three who are the breadwinners of the family, and you have people who rely on them for financial support. But what they've got to prove in terms of negligence is the same. That the gun was left out negligently. That the owner of the gun did something negligently. And if you can prove that, the next step of the action, and the place where you run into trouble, where you have a case like this involving children, is damages. Then you've got to prove what financial damages have those who are left behind suffered as a result of the child's death. And unfortunately, when you're dealing with kids who are 10, 11, 12 years old, that's usually where you run into problems, and you can't prove that they were making any money, or those people that are still left behind have what we call pecuniary loss. So I think it's a tough tough case, and it may be more symbolic on the wrongful death side than anything else.
And basically, the outcome of this would be just simply what, a monetary settlement?
Well, they're probably, my guess is that what's involved here is the gun owner's homeowner's insurance. So there's probably insurance coverage, but the fact that it's in suit and we're picking the jury tells me there wasn't a large settlement offer made, or not large enough. And again, I think the problem is not that there's necessarily no fault or liability. Clearly, the gun probably should have been put away, but I think the problem is, even if there is fault or liability, what are the damages? You may get a victory, but it may be a nominal one. The only other alternative would be that the second action that might be available is what's called a survival action, and that would be a claim actually in the child's name if they were shot and then lingered before death. You have to prove conscious pain and suffering. Essentially, it's a personal injury action that survives after a person's death. The estate inherits that action and then can bring it, but what you've got to show is that there was a gap in time between when the injury occurred and when the person passed, and then you can try and go after conscious pain and suffering in that regard. It's not an action that belongs to the people who are left behind, but the actual person who passed on.
Hey, Chaz, thanks a lot. Enjoyed the visit.
You too, guys. Take care. Have a great day.
Yeah, you too. We'll talk to you soon. Chaz Farcher, our legal analyst from Martin, Harding & Mazzotti.